the quorum has not changed.
On the defense, the quorum has not changed.
Okay. So it took me longer than I thought I would need to write them. So this is my ruling on the bail. 19 accused persons have been presented to this court and taken plea on various charges. They appear variously and in subsets in the total of 27 charges presented before court today. This ruling is chiefly on the consent. It's necessary to state that the state does not oppose bail. Their plea to this court is that it takes into consideration the nature of the charges, each of the accused, sanctity of trial. The state also argues that the accused persons and their legal representative are to observe the sub judice rules strictly. The state also seeks that there be a countermand against the accused's interference with a constitutional right. They went to great lengths to show that the charges were not as serious as are in many similar matters. They pointed out further that government, as they were subcontractees in the tenders or bids forming the basis of these charges. In buttressing their plea for reasonable bail, they stated that they had cooperated with investigative agencies, and further that they state that they will comply with the court's direction and are willing to deposit their passports in court and limit their movements out of court's jurisdiction. It was also their statement that they would comply strictly with the sub judice rule. They urged the state to also favor that rule in this matter. The defense further pleaded that with the court to take into consideration that one of the accused persons is a person living with disability and also is of fragile health. Further, that court should note that most of them were from the same extended family, and therefore terms of bail should be such as not to strain the family resources exceedingly. They ventured to suggest that a cash bail of 50,000 would be reasonable and should be the upper limit. The defense reiterated that each of the accused persons should be individually considered in terms of their unique circumstances and involvement in the matter. It is necessary to state that of the 19 accused persons charged, only the first 11 accused are natural persons. Accused 12 to 19 are all inclusive are juristic persons. Bail being unopposed, the only issue for the court to determine is what is reasonable bail in the circumstances of each accused vis-à-vis the demands of the law. Section 123A of the Criminal Procedure Code provides 4 statutory provisions in reaching a decision of bail and bond. 1, the nature and seriousness of the offense. 2, the character, antecedents, association, and community ties of the accused persons. 3, past records and fulfillment of the obligations under previous grants of bail. And 4, the strength of the evidence of commission of the offense against the accused. In determining the bail bond terms, the court will take into consideration only 3 of these listed above, as I have no information brought to court on the third limb as listed above, which is the past records and fulfillment of the obligations under previous grants of bail. I will also take note of the charges each of the accused is individually facing. The second limb of those considerations, the community ties of the accused, it is not an issue that all the 11 accused persons are well rooted in their communities with family ties and otherwise engage in meaningful economic activities. This limb is favorable to all the accused persons equally. The differential will be the number and seriousness of the counts each of the accused have been charged with, and I will start with the 4th accused, who has been charged with only 4 counts. His terms of bail are set as follows: a bond of 5 million, in the alternative, a cash bail of 1.5 million shillings. Accused 6 and 7 will also be bonded on the same terms, a bond of 5 million, in the alternative, a cash bail of 1.5 million. Accused 2 and 3 will have a bond of 1 million, in the alternative, a cash bail of 400,000 shillings each. Accused 5 will have his bond terms set as for accused 2 and 3, which is a bond of 1 million, in the alternative, a cash bail of 400,000 shillings. Accused 8, his bond terms will be set at 8 million shillings, in the alternative a cash bail of 2 million. The fourth accused, who faces 16 counts, a bond of 10 million, in the alternative a cash bail of 2.5 million. Accused 9, 10, and 11, a bond of 1 million shillings each, in the alternative a cash bail of 250,000 each. Now let me take I have noted that the first accused is the one I read as the fourth accused. The first accused terms of bond are as follows: a bond of 5 million, in the alternative a cash bail of 1.5 million. And for accused 4, a bond of 10 million, in the alternative a cash bail of 2.5 million. Please let me confirm that we are all clear on the terms we have set for each of the accused. Defense counsels, any clarification needed? Okay. So the first accused is Wycliffe Wangamati, and his terms of bond are a bond of 5 million, in the alternative a cash bail of 1.5 million, and in the alternative a cash bail of 400,000 each. These terms also apply to the fifth accused. The eighth accused is a bond of 8 million, in the alternative a cash bail of 2 million. And then we have accused 9, 10, and 11 banded together, each within 7 days. None of the parties are to leave the court's jurisdiction without leave of court. All party officers. The accused persons are neither to contact nor interfere with any of the witnesses by themselves or through their agents. Breaches in any of these terms set may attract legal consequences, which are not limited to cancellation of bail. Further, prosecution will provide all documents to be relied on in the matter, as well as provide witness statements. The court vested of the matter shall give further directions on pre-trial hearing. Further directions and hearing. So we'll have a mention in 14 days. Please guide me on the 17th. Any objections to our mention on 17th of October? Sorry, September? Okay, so you'll be appearing before court number 2. Maybe the day after? Okay. Which day of the week is 18th, Brenda? Thursday. So we have changed the date to the 18th of September. Anybody who wants any clarification? I'm done with the matter. I want to fold the file and do something else. You'll clear the court so that we hear the other matter. Okay. So I give you some 10 minutes. So are you the same counsels appearing in the other matter, the other plea we are taking? So let me leave court so that we can allow these ones to exit. Huh? Mr. Wanyama? Oh, okay.
No, we don't have it. You get the next. Let's get the lead.
Tupache tu cuts zake.
Statement was issued on Friday.
Hatuwezi kata na wewe anakuja. Si tunataka tushikanishe miguu alafu tuishike. The guy is a national security threat. No, the 2 million was for the contract, but there's some money transferred in his and transferring himself his does it?
Good afternoon. SCC E050 of 2025, Hilary Kipngeno Barchok. Evans Kipkoech, correct? That let's say from record who are here. Please take a seat.
Yes, Mr. Monda, I appear together with Ms. Gatiru.
So Mr. Monda, Ms. Deteru, Mr.
Akula, Mr. Nyamache, and Mr. Mosavi. Ms. Kigi, that is K-I-I-G-I, is watching me for the ESCC.
Good afternoon, Your Honor.
Good afternoon.
In this matter, my name is Issa. For the first accused, I appear with my line friends, Mr. Edward Wangamati.
Is a R.
I-double-S-A.
A.
Yes, I-double-S-A. Your Honor, in this matter, I appear with my line friends, Mr. Edward Owange. They're all seated in the second row.
Present, Your Honor.
Mr. Robert Ocheng.
Present, Your Honor.
And friend Mr. Abdelrazak.
Kindly spell that name again.
Abdi.
Abdi.
And then Razak.
Abdi Razak. Is
Abdi
it one
Razak.
name?
Yes, that's one name. Abdi is just the beginning and then end to Razak. And lastly, Mr. Hassan Nura. Yes, yes. He's an advocate of high standard.
But a friend of the court.
Yes. And Mr. Stephen.
The second accused is the director for the third accused, the accused person.
Any other friends of the court? So simply, as I've explained to you, please bring that to the kindly stand up. In count number 1, Hilary Kipngeno Barchok, you are charged with the offense of conflict of interest contrary to section 42, as read with section 48 of Anti-Corruption and Economic Crimes Act, cap 65. Particulars of the offense are between 14th November 2019 and 10th March 2021 at an unknown place within the Republic of Kenya, being the governor of the county government of Bomet, you knowingly acquired an indirect private interest with 2 million shillings in respect of contracts emanating from tender number CGB/ARB/006/2019 to 2020 routine maintenance of Kimenderate Kotoibek Olbutio Bridge Road, and tender number CGB/DRP/004/2018/2019, hire of grader awarded to Chemasus Construction Limited by the County Government of Bomet. True or not true?
Not true.
Count 2, Hillary Meno Bartok. You are charged with the offense of acquisition of proceeds of crimes, contrary to Section 4A, as read with Section 16 of the Proceeds of Crime and Anti-Money Laundering Act 59B. Particulars are: on or about 10th March 2021, within the Republic of Kenya, being the governor of the County Government of Bomet, you acquired a sum of 2 million shillings in your Equity Bank account number 122806453130 from Chemasus Construction Limited, Equities Bank account number 12202774568887, while having reason to believe that the said monies formed proceeds of crime, to which monies were received irregularly in connection with contract awarded to Chemasus Construction Limited by the County Government of Bomet. True or not true? Count number 3, Hillary Kikneno Bartok. You are charged with the offense of use of proceeds of crimes contrary to Section 4B, as read with Section 16 of the Proceeds of Crime and Anti-Money Laundering Act 59B. Particulars are: on or about 15th March 2021, within the Republic of Kenya, you transacted a sum of 300,000 shillings from your Equity Bank account number 12202806453130 to your Equity Bank account number 02101979399281, and having reason to believe that the said monies formed proceeds of crime, to which monies you received irregularly from a contractor of the County Government of Bomet. True or not true?
Not true.
Count number 4, Hillary number 2. You are charged with the offense of use of proceeds of crime, contrary to Section 4B, as read with Section 16 of the Proceeds of Crime and Anti-Money Laundering Act 59B. Particulars are: on or about 20th March 2021, within the Republic of Kenya, you transacted a sum of 314,000 shillings from the Equity Bank account number 12202806453130 to Equity Bank account number 12205804836652, and having reason to believe that the said monies formed proceeds of a crime, to which monies were received irregularly from a contractor of the County Government of Bomet. True or not true?
Not true.
Count number 5, Hillary Kikmeno Bartok. They are charged with the offense of use of proceeds of crime, contrary to Section 4B, as well as Section 16 of the Proceeds of Crime and Anti-Money Laundering Act at 59B. Particulars are: on or about 20th March 2021, within the Republic of Kenya, you transacted a sum of 100,000 shillings from Equity Bank account number 12202806453130 to your Equity Bank account number 02101979399281, while having reason to believe that the said monies formed proceeds of a crime, to which monies were received irregularly from a contractor of the County Government of Bomet. True or not true?
Not true.
Count number 6, Hillary Kikmeno Bartok. Use of proceeds of crimes contrary to Section 4B, as read with Section 16 of the Proceeds of Crime and Anti-Money Laundering Act 59B. Particulars are: on or about 29th March 2021, within the Republic of Kenya, you transacted a sum of 750,000 shillings from your Equity Bank account number 122028 from a contractor of the County Government of Bomet. True or not true?
Not true.
Count number 7, Hillary Kikmeno Bartok, Evans Kipkoech Korir, Construction Limited, are charged with the offense of money laundering contrary to Section 3B1, as read with Section 16 of the Proceeds of Crime and Anti-Money Laundering Act of 2009. Particulars are: on or about the 10th March 2021, formed proceeds of crime, you entered in an agreement to transact the said sum of money from Chemasus Construction Limited, Equity Bank account number 12205130 in the name of Hillary Kikmeno Bartok, whose effect was to conceal the source of the said money. Hillary Kikmeno. True or not true?
Not true.
If Evans Kipkoech from 1 to 7 are inclusive, also other plea of no guilty is entered against the second and third accused in count 7. defense.
Let's start with the prosecution.
Yes, Your Honor. Of the accused persons on bail, bond terms, save to indicate to the court that upon release on bond terms, taking into account the nature of charges that they each face, of the court without permission of this honorable court or the trial court. In addition, upon service of the evidentiary material by the prosecution, they should not contact or interfere either by themselves or through their proxies with the prosecution witnesses. In case each of the accused persons holds a passport and seek the permission of the court in case they wish to travel outside the country. Therefore, ask the Honorable Court to take into account the nature of charges in releasing the accused persons on bond or bail. Maybe, Your Honor, before I turn off,
Yes.
they should also not make any comments, either by themselves or their proxies, regarding this matter, except in court, in order to preserve the integrity of the proceedings.
Thank you, Your Honor. On behalf of the Honorable Dr. the first accused, well, we kindly request you to consider that the prosecution first has considered that they have no objection to the accused persons being released on bail or bond. You know, His Excellency the Governor was out of the country when the Honorable DPP issued his statement on Friday. Greece on an official visit. As soon as he was notified of the communication from the office of the DPP, although he was on an official visit, he cancelled that official engagement and traveled back on Sunday to be here to present himself before the ESCC on Monday morning. And throughout the investigation, at any time they required him to appear before their officers, they did not need to send their van, which is it's a very popular method of them ensuring compliance. He has always appeared on his own account, using his own means at the ESCC. And as second-term governor, he undertakes to cooperate with be here as and when required for any of the hearing sessions. He has no intention of interfering with any of the witnesses. He is keen to have this matter proceed expeditiously so that his innocence can be confirmed by this honorable court. And so, Your Honor, this is one of those exceptional cases where we'll be kindly requesting that the court releases him on a free bond, or technically in his own recognizance, that he undertakes to appear at any time that he'll be required by the court. And looking at the charges, there are only 7 counts. And the majority of those counts deal with the Honorable Governor moving money from his own account to his account. So this is a kind of charge where my learned friend Mr. Monda will have no problem if the Honorable Governor should release him a free bond, because he'll be here as and when is required. And from the defense team, we are not known to be people who comment on cases. None of us is prolific either in Twitter or any of those other social media places. So we'll not interfere with this proceeding in any way. So for those reasons, and the reasons that our client is a senior public servant, serving the good people of Bomet, we kindly ask you to give us a free bond, or if the court is inclined to ask us to deposit a cash bail, we would suggest very humbly a sum of 100,000 would be reasonable to balance the interests of the prosecution and the interests of the first accused. Thank you.
Do any of your co-counsels intend to say anything?
No, you don't have to.
It's spoken for all of us.
Okay, thank you. Mr. I want to call you a bold name, I knew you. Anyoka.
Yes.
He's usually very careful
With
to
the
say J.
conspicuous A. With the conspicuous
No,
A.
he's an officer of the court.
Without the A, then you have a defective quorum.
Yes,
You are, on
Mr.
behalf of the second and third accused, I have instructions to visit the court to admit the second accused on not just reasonable, but lenient bond terms. Your Honor, as you consider the terms, I urge the court to be alive to the purposes, values, and principles of the Constitution, in that bail, bond, is a constitutional right, and that as you consider those terms, they should not be such that they impede the accused person's access to justice. At the same time, Your Honor, the same should not be in a manner that it affects the fair hearing of this matter before the court. Maybe on specific facts to guide the court as it retires to consider what kind of terms to describe or prescribe. The accused person has an established home at Chepole, that's within Bomet County. He is a businessman, but more importantly, he's engaged in dairy farming and makes a significant contribution to the food security of this nation. Besides that, the accused person is a family man. He has very strong family bonds, and the village looks up to him. For guidance. Your Honor, during the subsistence of the investigations, the accused person cooperated fully. He could answer calls as and when they were made. He followed up missed calls by following up by making calls to the investigators. He provided any information as and when required. He has never displayed or demonstrated any indication of a possibility of him absconding this court process. Your Honor, yesterday, that is on 1st of September, the accused person received information from a friend that he had seen through the media that he was required to attend at the EACC offices yesterday at 8. That's on 1st September 2025. Through a friend, he contacted me and requested me to proceed to EACC headquarters to plead and ask them to postpone his appearance to Wednesday, that is 3rd of September 2025. The reason being that he received this information very late, and in addition to that, he had a sick patient who required urgent medical attention. I proceeded to EACC headquarters on behalf of the second accused, and I'm happy and thank the EACC officers. They indulged my client and me, but on a personal undertaking to produce him on 3rd of September 2025 before the EACC headquarters. Your Honor, I did a letter which was received, and there's Your Honor, if you look at that letter, I made a personal undertaking to produce him on 3rd of September 2025. However, in unprecedented and precedent-setting action, the second accused called me and informed me that the doctor has confirmed to him that his patient is out of danger and that he would wish to rush to Nairobi to appear before the EACC and be processed for production before court. I advised him that we had an extension or the same as we deferred to 3rd of September. He said, no, I want to process immediately, clear myself, and face another life with a clear set of mind. He then rushed Nairobi. At around 3 was at Westlands. There was a heavy traffic snarl. He elected to use a border rider to be available for the EACC at around 15 p.m. Though they were winding up and closing the offices, he insisted on being processed. He could not afford to wait any longer. Your Honor, that special and unique act from my client is something that I have not witnessed for over 20 years of my practice. As a practitioner and as an ordinary citizen. First, in similar circumstances, I would have opted to be here on 3rd of September 2025. But on his own volition, he elected to bring forward the date for being processed and charged. Your Honor, with such kind of unique demonstration from the second accused, this is a situation where the court should go an extra mile and release the accused person on a free bond. And as a reward for such an exemplary, rare, and unique act. That is indeed a Kenyan who is so obedient, so religious, and so determined to face justice, go through the criminal justice system, and clear himself. On the issue of the amount of cash bill, I saw he had started some WhatsApp group trying to invite friends to raise some money for him. And it's just shown me that it's raised around 15,000. We believe by the time maybe the court concludes declaring the bond terms, he shall be able to raise some Kenya shillings, 20,000. But otherwise, this is a fit case for this on a free bond. Thank you.
Yes, that's what you say. We need to
Yeah,
make
it's just something like on the issue of the comments on about concerning this particular proceedings.
Yes.
Concerning on the part of my client, the application by the prosecution concerning comments on this particular case, it appears the prosecution is making an application against themselves. It's the prosecution who have elected to prosecute this particular matter to the media. We've seen breaking news, immediate release, high-profile arrests. My client, who is a humble person, and as I indicated earlier, is a dairy farmer. It's not a danger at all.
Goes to the cows.
On the issue of him absconding, we've already.
Yes, just to give me that issue, all I say is that the matter is now within the domain of the court. Will be deemed sub judice. So therefore, going forward, there should be no comments. Secondly, we reiterate that you should individually look at the charges each of the accused person is facing. And in our view, direct that they be released on bond terms. Not free bond. That should be okay.
Mr. Mansuri, on your face. Oh, it's that you don't have a seat.
I'm anxious to get the bail terms.
Oh. You'd allow me some 30 or 40 minutes of given me.
That's what you will do.
That will take us to about
1:30?
1:30 there.
That's fine. That's okay now.
So we'll resume for 10.
Thank you.